Hello, it's Phillip Taylor speaking from Richmond Green Chambers in London. Today I'm looking at a book which has come to us from Sweet and Maxwell, Thomson, Reuters. It's a very interesting and important book. It's called Disclosure. In fact, the full title is Matthews and Malek on Disclosure. It's the 5th edition of a book which started out with the title Discovery, because it's about discovery of documents. It's been written by Paul Matthews and Hodge, Malek, Queen's Counsel, and there's an excellent foreword by Lord Justice Briggs. Now, Elizabeth and I have given a title for our book review, the following: Coping with the difficult subject of disclosure, no litigator should be without this definitive work, which is now in a new edition. Let's have a look at the book first of all. Here it is. It's a heavy book. There we go. Hardback, blue cover, with a red note about it. It's part of the litigation library service for Sweet and Maxwell, and you can see there's nothing on the back. The book runs to quite a substantial number of pages, 800 odd. There's a standard index at the back, which is about paragraph, which is actually referring to paragraph numbers. So you don't have page numbers, you have paragraph numbers, and it follows the legal taxonomy structure, which is part of Sweet and Maxwell and the way they do things in their house style. And there's some appendices at the back, forms and so forth. And you can see in the book itself paragraph numbering at the sides, and of course quite substantial numbers of footnotes. It's a substantial work which is revised on a regular basis. This is the information about the book and the litigation library itself. There we go. And you've got basic information about the book. The first edition came out in 1992, so it's been with us for a long time. There's a very useful foreword which sets out what has happened since the last edition, and that's been actually written by Michael Briggs in November 2016. And then you had a foreword, you actually have a foreword to the earlier edition, the 4th edition, which looked at the Jackson reforms and so forth. Then there's a main preface there, which sets out exactly where everything is. Again, the main preface actually is from November 2016, and it does actually look at quite a number of the cases which have come in, because this is a case heavy subject. There's the contents section there. You can see it's a substantial number of parts and chapters running all the way through. All the usual stuff is there. You can see there's a useful amount of information on experts towards the end of the book. The total number of chapters run to 25, and there are 3 appendices. Chapter 25 deals with Human Rights Act. Then you have the cases, a large number of cases running all the way through, and then after the cases you get to the statutes as well, of course, there. And after the statutes, some statutory instruments. You see a very large number of cases covered in this book. And of course, then there's a table of civil procedure rules. Very important, of course, in this area. It's growing very substantially at the moment. Then there's a table of European legislation, also very useful, and table of practice directions. So you've got a large amount of information there. And then the rules of the Supreme Court itself, the old RSCs, and they actually cover other jurisdictions as well. You can see that from there. And then you get the structure, the various chapters. For each chapter you've got a short index to show what's actually in it. And then it runs through, and you can see, as I say, the paragraph numbering and footnotes. It's a heavy book and a very important book for everybody who is involved in any form of litigation and court work, because it's about how you run your case, basically. So what do we say? Elizabeth wrote most of the review. We had a long discussion about the book and what we were going to say about it. And this is what we say then. Discovery, as the former title of this classic and authoritative legal text indicates, does mean disclosure. And yes, it does refer to the discovery of documents, which of course we all know as practitioners is the sort of phrase we use. You could describe disclosure as the core procedure by which documentary evidence is procured, i.e. discovered, in support of the respective allegations put forward by the parties involved in a dispute, which leads to a hearing. And in the common law jurisdictions, which feature the accusatorial system, preparation for a trial necessarily takes place in advance. Therefore, the principles of disclosure are what every litigator needs to know. And that's a very fundamental problem, which I've certainly come across, and I'm sure you have, with clients. They seem to think they can hide things and then suddenly ambush the other side. It doesn't work like that, and of course that is one of the reasons why we have got to have fairly robust rules. So now in a new edition, the 5th edition from Sweeten, Maxwell and Thomson Reuters, this title, which is now Matthews and Malek on disclosure, offers the means by which litigators may enhance their understanding of and practical knowledge of what Lord Justice Michael Briggs refers to in the Foreword as this most difficult subject. The two authors, Briggs says, have dedicated themselves over 25 years to the creation and subsequent maintenance of a masterly and constantly updated analysis of an aspect of civil court procedure which never stands still. That is absolutely true, and that's one of the reasons why there are so many cases which are referred to. And I can remember my first reading of civil procedure when I was doing civil litigation, when I was doing the bar course, and I was amazed at how many cases there were even then, and of course it's expanded since then. Now, there's a quote which I think is quite useful. Disclosure under English law is given in a variety of ways, say the authors Matthews and Malek, and a detailed exposition of these is the main subject matter of this work. The three general characteristics are covered, which are documents, information and real evidence. And across 24 chapters and 900 or so pages, the exposition of the subject is vast, thorough and distinguished by its clarity, an aspect of the book which will be appreciated by seasoned practitioners and novices alike. And I'm glad, because I do recall some of the books a few years ago, which will remain nameless, were not the easiest books to read, and I can remember the White Book in a rather different guise a very, very long time ago, which really was not the easiest document to read. It was very complicated and you really had to have your wits about you. So, where are we today in 2017? Well, part one of this book is the introduction. It makes particular reference to the Civil Procedure Rules 1998, which get their own little section with the practice directions, and ultimately have engendered a new legal landscape, as we know, in which compliance with said rules is fundamental. And that is again something which litigators are always very careful to keep to where they can. It's amazing, though, how often the rules are broken, and yet there has to be that balance that is always sought to be achieved in the interests of justice, to make sure that there is fairness throughout. Now, part two, which is the bulk of the book, provides a detailed and thorough examination of disclosure of documents, covering the time of disclosure, the means of disclosure, what must be disclosed, and of course much more, in view of what the authors refer to as the torrent of disclosure case law that has threatened to become a deluge during the past 5 years since the publication of the previous edition of the book. And you will see that there have been, with previous editions, supplements to take account of this. It's a little bit like the law of evidence, where there's so much case law coming up that you really have got to keep a very close eye on what's happening. And to cite only a couple of examples here, Chapter 5 deals with the 2003 Jackson CPR reforms, and Chapter 7 deals with electronic disclosure, which have had to be rewritten. Now, you'll appreciate that even now, I suspect we're going to have very substantial changes in the next couple of years. We have a general election on the 8th of June 2017, and thereafter we will have the representation, presumably, of the Crime and Courts Bill in whatever form it is, and that will be looking very much at the digital era. So, as access to and reference to case law is of prime importance in this area, I think practitioners will welcome the 170 pages, no less, of the following tables. And here's the list: cases, made up the majority of it, statutes, SIs, European legislation, CPR, PDs, and the rules of the Supreme Court. Now, let me conclude by saying that another essential feature which has lessened the book's usual bulk somewhat are the three appendices, which list all the website addresses for information for relevant statutes rules of court and forms and so forth. And what a vital, dynamic and useful work of reference this text continues to be, both for the practitioner, the student and any other persons interested in. Especially I think it would be of help to litigants in person, of which there are such a large number, certainly in the lower courts. It's easy to navigate too. I didn't find it difficult. It's very well written. No litigator, therefore, in our view, can afford to be without a copy, and the publication date is cited at 2017. Let's just have one look at it again. There's the front, the side, nothing on the back. Opening it up in the middle. Duty of search, form of disclosure. There we go, it's right in the middle. You've got paragraph numbering, you've got all the footnotes there and there, and paragraph numbering at the sides, and you can see it runs through injunctions. Here we go, privilege from production for inspection and so forth. Again, very important as to what you can and what you cannot do. A rather different problem arises where a party to litigation is already subject prior proceedings to an injunction. So you've got to bear in mind all the different types of problem that can arise with disclosure. That's just one of them with an injunction. Anyway, I'm very pleased with this book. I think Matthews and Malek have done a first-class job. I'm very grateful to them for the fact that they are making our lives so much easier by producing this work, because at the end of the day we have to have really good tools at our disposal with the wealth of information, CPR and all the other things that we've got to deal with. And of course the effect of the case law decisions. So therefore this book is very timely, and I've no doubt there will be another edition before too long. In the meantime, thank you to Sweet and Maxwell for running the publication again, and also of course to the very hard work of all the people involved in producing this book. Thank you. Bye-bye.